Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
So this is session 2 of the Walker Supreme Court in the Canadian Bar Association courtroom, and court is now in session. We would like to acknowledge that we are speaking to you today from the traditional unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin peoples and all Indigenous peoples in the region of Ottawa who call the national capital their home. If you are not located in Ottawa and do not know, if you're not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate the website like nativeland.ca to find out. And we also encourage that you learn about the decolonization by consulting the TRC calls to action as a starting point. It is with great honor and privilege that I present Justice Dr. David Miller of the West Toronto Dental Association, Justice Andrea Donaldson from Pacific Medical Law, Justice Dr. Louise Harris, Professor of Medicine at the University of Toronto and Staff Cardiologist at the Peter Munk Cardiac Center, Justice Elizabeth Bratton from Borden Lardon Jarvis LLP, and Justice Dr. Eric Cohen, Deputy Head for the Division of Cardiology at Sunnybrook Hospital, Schulich's Heart Center. So now I'm just going to go over some of the facts from the case. So on October 19th, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward for Fall View Health, 13 hours after her transfer from West Valley Memorial Hospital. Mrs. Stark's medical records reveal she was in perfect health and she had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her long-term physician, Dr. Sonia Strange, and obtained a prescription of ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5th, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled. But the same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the Defendant's Hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Ms. Stark immediately requested Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. My apologies. On October 6th, Ms. Stark was moved into the ICU and placed on a nasal cannula during the day and a BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dextromethorphan and pure oxygen. On October 7th, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadopoulos. With 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Ludizier, chose to withhold any further administration after being informed by Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Ms. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Ludizier was contacted by Dr. Strange, who strongly requested ivermectin to continue to be administered in addition to the MATH plus protocol. In response, Dr. Ludizier and Dr. Strange to forward him the relevant literature for which she was relying on. so that he can make a rational and educated decision, which provided immediately after Dr. Ludiser determined his time would be better spent attending to patients than reading what he referred to as propaganda. On October 10th, ICU nurse Dolores Patel was convinced by Mr. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the Frontline COVID-19 Critical Care Alliance MATH Plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Mrs. Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Ms. Stark's condition had improved, at this point having only to rely on a nasal cannula. On the morning of October 13th, Ms. Stark's family was informed by Nurse Patel and the hospital had misplaced the ivermectin, but there was no need for concern as Ms. Stark was making great progress. However, Dr. Ludiser once again assumed care of Ms. Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the MATH Plus protocol. Dr. Ludiser then administered remdesivir to Ms. Stark. Nurse Patel phoned Ms. Stark's family and informed them that Dr. Ludiser had assumed care and denied any further administration of the MATH Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of the initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Ms. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Ms. Stark was again placed on a ventilator. The family arrived at the hospital, but was denied access due to the hospital's COVID-19 protocol in place. Mr. Starks phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Ludiser, but after 4 unsuccessful phone call attempts, decided to drive down to the defendant's hospital and attempt to manage the situation in person. Upon her arrival, Dr. Strange was denied access to Mr. Stark and was unable to speak with Dr. Ludiser. Within 6 hours, Ms. Stark's chances of survival had dropped to 20%, and Dr. Ludiser informed Mr. Stark that he had exhausted both his course of treatment and COVID-19 protocols in treating Ms. Stark. Mr. Stark pleaded with Dr. Ludiser to administer the MATH Plus protocol and offered to sign a release, releasing Dr. Ludiser in the hospital of any agents and parties acting on its behalf from any and all liability arising from the administration of the MATH Plus protocol to his wife. However, Dr. Ludiser refused to administer the MATH Plus protocol from verbal confrontation ensued. Outside between Mr. Stark and medical staff, and security removed him from the building. On October 19th, Dr. Ludiser agreed to transfer of Ms. Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assure care for her. However, less than 1 hour after arriving at Fallview Health, Ms. Stark died. In this matter, the question at issues are the following. Issue A, standard of care. What is requisite standard of care for medical negligence in Canada as correctly applied to this case? 2, did Dr. Ludiser breach the standard of care in A, failing to investigate the literature he was provided with, and B, denying Ms. Stark treatment with MATH Plus over ivermectin alone? Issue B, causation. 1, did Dr. Ludiser conduct, cause, or contribute to the harm or injury Ms. Stark sustained? And issue C, vicarious liability. Is the hospital vicariously liable for Dr. Ludiser's actions? Justices of the panel, I present to you speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Alexander Robbins and Owen Guinn. And speaking on behalf of the defendant, Dr. Ludiser, in the West Valley Memorial Hospital, Basil Sabalbal and Ethan Zavarella. We are here today to determine the outcome of trial before the court on the matter between Mr. Stark and Dr. Ludiser in the West Valley Memorial Hospital. Both the plaintiff and the defendant counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to this court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they choose so. I will signal the court when there are 5 minutes left per speaker. The court invites the plaintiff to begin. Counsel for the plaintiff to begin.
Thank you. Good morning, justices. My name is Alexandra Robbins, counsel for the plaintiff, and I'm joined by my partner, Owen Guinn. We ask that the court hold the defendants, Dr. Justin Lutzier and West Valley Memorial Hospital, jointly liable for Ms. Kyla Stark's death. The plaintiff seeks $25.34 million in damages. We have 3 submissions to make before the court today. First, I will submit that Dr. Lutzier breached the requisite standard of care while treating Mrs. Stark. Second, my co-counsel will submit that the breach of the standard of care caused Ms. Stark's death in law. And third, he will submit that as Dr. Lutzier's employer, West Valley is vicariously liable for Ms. Stark's death. There are multiple elements of negligence required at common law. Some of them are uncontested in this matter, so I'll address them briefly first. First, duty of care. It's widely recognized in the jurisprudence that in relationships involving supervision and control, including the doctor-patient relationship, a duty of care is presumed. Thus, Dr. Lutzier owed a duty of care to Ms. Stark as her physician. Second, general establishment of damages. Bodily harm is generally sufficient, as was noted in Mustafa and Culligan. Therefore, death is certainly enough to meet this threshold. Turning to the first contested element and the first issue in this matter, standard of care. To be clear, we're in agreement with our friends that for medical negligence, the standard is that of a reasonable physician in the defendant physician's circumstances. More specifically, since Dr. Lutzier is a specialist in pulmonary and critical care medicine, the requisite standard of care would be that of a specialist in his circumstances. The issue before the court is, what does this entail? What would a reasonable specialist have done in Dr. Lutzier's circumstances? Our friends have submitted that the answer to this question lies primarily in the chosen treatment itself, in this case, supportive care. Now, we agree with the defendants that supportive care is a customary practice in the medical profession for treating COVID-19, and it was adopted by the hospital. We don't dispute that. We also agree with the defendants that typically, adherence to customary practices will absolve a physician of liability. This was noted in Terneuzen and Korn. However, customary treatments are not sufficient to establish a standard of care. Physicians do much more than simply provide treatments. And it's for this reason that there have been found to be breaches of standard of care where, for example, a physician fails to consult a patient's medical history. Standard of care, therefore, goes beyond treatment alone. And one might look to a few different places to get a more holistic picture of what a standard of care is in any given circumstances. For one, we might look to expert testimony of other specialists or physicians in the field. And we also might look to the College of Physicians and Surgeons of Ontario's practice guide, which lays out duties, obligations, expectations of physicians that are bound or governed by the college. Turning therefore to the impugned breach, we submit that Dr. Lutzier breached the standard of care in 2 ways. Turning to the first, Dr. Strange, Ms. Stark's primary care physician, attempted to contact Dr. Lutzier regarding the potential administration of ivermectin as she had prescribed it. He did ask for her to send over the literature that she was relying on to make this determination, and yet he didn't review it. Now, there's 2 sources of evidence which suggest that this was a failure to exercise reasonable care. First, we can look to the duties in the CPSO's practice guide, and there's 3 relevant duties here. First, there's a duty to collaborate with other healthcare professionals. This might include the exchange of information and shared decision-making. Here, although Dr. Lutzier did ask for the research, he didn't read it. Therefore, there was no collaboration with Dr. Strange. And when she did contact him and ask for a phone call, he declined that as well. Second, there's a duty to learn, which essentially means seek out new evidence and knowledge, keep abreast of current developments in the field. Now, this material was presented to Dr. Lutzier as being potentially life-saving, potentially novel, something that he hadn't been exposed to before. This would be a supposed current development in the field. And this is especially troubling that he didn't read these materials, given that he acknowledged in his discovery the evolving nature of COVID-19 research, how quickly it changes, and how he must keep abreast of this research. Third, there's a duty to demonstrate professional competence. And one key component of this is to demonstrate a sense of inquiry. And similarly to the previous duty, there was no demonstration of that in the failure to read these materials. Your Honors, beyond the duties laid out in CPSO's practice guide, We can also look to expert testimony from other specialists in the field to determine whether or not reading these materials would have formed part of the standard of care of a reasonable specialist in Dr. Lutzier's circumstances. First, we can turn to Dr. Lutzier's own statements that he made at discovery. He himself noted that the exchange of research by colleagues is standard practice in the medical field, and even more so during the COVID-19 pandemic. He also noted that should he be faced with a scenario where a colleague were to send him studies regarding novel treatment options, quote, he would engage in a formal discussion with his colleague and then read what they sent him in keeping with his duty as a medical specialist. He claimed that since, quote, it's life-saving or claimed to be, you have to investigate. That would be his duty. These were Dr. Lutzier's own statements, and yet when applied in practice, he did not follow through on them. He did not investigate the supposedly life-saving literature provided to him, regardless of whether or not it turned out to be so. Second, we can look to other specialists. Dr. Moriarty, a critical care physician, and Dr. Titchener, an expert in pulmonary and critical care as well. They both stated that they would have read the studies if they were in his circumstances. For example, Dr. Titchener stated, quote, you are, as ICU physician, left with the choice of watching your patient die or sitting down and reading a few studies. Standard of care here is you adapt to the situation, assess the patient, speak with the prescribing physician, do your own due diligence, and make a decision.
Counsel, could I interrupt for a moment to ask a question? You alluded several times to the presumed duty to read the literature, read the studies. Can you elaborate a bit more on what you mean by read? Do you mean literally read? Or do you mean, because I would contend that with the volume of evidence and so on, reading is more than simply reading.
Absolutely, Your Honor, and thank you. To clarify, yes, well, we'd submit, there's no essentially one size fits all as to how a physician is to assess literature, but we'd submit that an assessment or a reading that's close enough to make an informed decision. So of course, physicians are very well versed in reading literature. They might read it in different ways. Some might focus more on the conclusion section of a paper, so to speak. But in this case, the issue was that there was essentially no assessment at all. In his discovery, Dr. Lutzier, when describing the materials sent to him, he said there were 5 or 6 studies or something like that. And yet that's not even what was sent in the email. He was sent a meta-analysis, which suggests that he didn't even look closely enough to know what was sent to him. So it might be, whether it be, for example, a close, thorough reading or a review of a conclusion section, we're simply submitting that the duty here would require enough of an assessment to make an informed decision.
The reality is that meta-analysis that is cited in your factum had about 40,000 words and 240 references. So I question how realistic it is that the doctor would be able to actually interpret rather than just skim that sort of material. I'll stop at that point. Thanks.
Absolutely, Justice. Well, I'll just say one more thing. With the meta-analyses, of course, again, there's always a conclusion section, something that sums up the research. We submit that, of course, we understand Dr. Lutzier is a very busy doctor. He could have looked to those sections, gotten a review, or in the alternative, he could have picked up the phone and spoken to Dr. Strange. She expressed that she was absolutely willing to do that. Had he wanted a sort of short briefing on the research, he could have done that as well. And of course, we recognize that he's busy, but it's also worth noting too that he has said himself that he does put aside time to read the research, especially in the COVID-19 pandemic. So given that he does say that at times he puts the time aside to do the research, we don't feel like this is an unreasonable request. Turning back to
Counsel, sorry, can I just ask a quick question? You mentioned Dr. Lutzier's discovery. Was he asked upon discovery if he, at some point during this case, did he eventually read the studies he was provided with?
My apologies, I don't have the citation in front of me, but to my recollection, he noted that he did not end up reading them at all. But what's critical here is, did he read them at the time? So in looking at breach of standard of care, the question is whether or not, before making an informed decision regarding the treatment of the patient, did he assess the literature? But don't quote me on it, but I'm pretty sure that he hasn't since read as well.
Okay, my point's just being, we don't know what if he had read the literature, if that would have changed his conduct at all.
Absolutely, Justice, and I'll get to that, but that's not necessarily critical to the outcome. So when we're looking at standard of care in isolation, the question is simply whether or not was failing to read the literature a breach of the standard of care, regardless of his ultimate decision. And when I get to the second breach that we're presuming, we are not suggesting that Dr. Lutsier had one option, which was to administer Math Plus or ivermectin. We're submitting that there was an alternative, which was also to transfer the patient, given that it was clear that the family, her physician, wanted ivermectin to be administered. So turning back to expert testimony, we can also look at, for example, Dr. Papadopoulos as an example. He initially refused to administer ivermectin, but he chose to engage in a review of the literature. This is noted in Mr. Stark's cross-examination, and then he ended up complying after he did the research. So although he wasn't called for discovery, his actions further support that reasonable physicians in this field would take the time to review the literature before acting. Now, since Dr. Lutsier failed to do so, we submit that this was the first breach of his standard of care. Second, we submit that there was a failure to exercise reasonable care with regards to not administering ivermectin or Math protocol, or in the alternative, transferring Ms. Stark promptly to Dr. Strange's care at Fallview Health. So first, we can again turn back to the practice guide of the CPSO. The CPSO outlines physicians' duty to collaborate with patients and others. It requires practitioners to, quote, work with the patient in order to understand the patient's healthcare needs, to formulate treatment plans that are optimal for the patient, and to address patient questions and concerns. Now, for an example of what collaboration looks like in practice, we can look at Dr. Papadopoulos and Nurse Patel and also Dr. Andy Park. They both collaborated with Ms. Stark's family and with her her primary care physician, Dr. Strange. And then after that, agreed to administer ivermectin or Math Plus. Yet in both of these scenarios, Dr. Lutsier came in, he stopped these treatments, and he unilaterally made that decision. So he did not collaborate with the patient, he did not collaborate with the family, and he did not collaborate with the primary care physician who initially had prescribed the ivermectin. Second, we can look to
me for a moment. You rely heavily on the CPSO practice guide to inform the standard of care of Dr. Lutsier. Could you direct me to a case in which the court also relied so heavily on the practice guide rather than on expert testimony?
Yes, Your Honors. Well, before I do that, it is somewhere in my factum. We would like to note, though, that the CPSO is being used in conjunction with expert testimony. So we would not submit that the CPSO is essentially the governing piece of evidence that we are using. With regards to the first breach, failing to read the literature, we'd submit that it's equally balanced between the guide and the expert testimony, if not the expert testimony being weighed more. And here we'll also be looking at jurisprudence. So if you may just give me a moment to locate that citation. So Justice, I'm not sure if you have your factum my factum in front of you. At footnote 16, there's a few different cases where the CPSO guide is referred to, and it's critical in those cases, just as this one, it's not relied on in isolation. It's relied on in conjunction with expert testimony, jurisprudence, etc. So, of course, so turning to the jurisprudence here, it's noted that where a physician fails to take into account relevant facts at the time of treatment, this may be a breach of the standard of care. So we would submit that's precisely what occurred here. And the relevant fact was that, and my co-counsel will elaborate on this much further, that Ms. Stark was improving under ivermectin and Math Plus. That was a relevant fact that Dr. Lutsier didn't take into consideration. Now, second, the jurisprudence also notes that a physician may be in breach by failing to provide a treatment of medical benefit. Now, what medical benefit means in the law context is not a scientific inquiry. It's noted in Cuthbertson and Rasuli that this is a patient-focused, contextual approach. So we look to the patient's circumstances, their condition, their prognosis, and their expected results. So here, again, Ms. Stark was improving under ivermectin and Math Plus. So we would submit that Dr. Lutsier, therefore, failed to provide a treatment that was of medical benefit at law. Your Honors, I do see that I've elapsed my time. May I briefly conclude?
Yes.
Thank you. To conclude, Your Honors, it's incredibly important to stress that we are not attempting to hold Dr. Lutsier to a standard of perfection. We're simply submitting that at multiple stages throughout this process, there was reasonable options available to him and that he didn't take them. We're not submitting that his only option was to sit, do a thorough review of the literature, and choose to administer ivermectin and Math Plus. He absolutely has discretion as a physician to not do so. But if that was the choice that he was going to make, we submit that Ms. Stark should have been transferred far earlier, as soon as that decision was made. So to sum, with regards to standard of care, we submit that there was 2 breaches. First, in the failure to to review the literature provided to him by Dr. Strange. And second, failing to administer ivermectin or Math Plus, or to transfer Ms. Stark promptly to Dr. Strange's care. Barring any further questions, Your Honors, I'll now pass it along to my co-counsel and he'll conclude submissions on behalf of the plaintiff.
Good morning, Justices. Are you all ready? Good morning. My name is Owen Guinn. I'm here today on behalf of the plaintiff, Mr. Sam Stark, and I will be continuing submissions begun by my co-counsel. I have 2 submissions for the court today. Firstly, that Dr. Lutsier caused Ms. Stark's death, and secondly, that West Valley Memorial Hospital should be held vicariously liable for his negligence. For my first submission, causation. The plaintiff must show that on the balance of probabilities, it is merely more likely than not that but for Dr. Lutsier's actions, Ms. Stark would not have died. In order to do that, we will first point to a variety of studies which demonstrate that ivermectin has sufficient evidence to be shown to be safe and effective in treating COVID-19 and reducing patients' mortality who are suffering from it. The first of these studies, as my co-counsel has already mentioned, is the meta-analyses provided by Dr. Strange to Dr. Lutsier in an email. That meta-analysis contained a review of 78 individual studies, which together showed a 44% reduction of mortality in patients treated with ivermectin versus those without, with a high degree of statistical significance. But the plaintiff acknowledges that this one meta-analysis alone may be insufficient to establish causation on a balance of probabilities. Therefore, we also look to another of other meta-analyses, such as one conducted by Cobos Campos et al., which found, after reviewing 53 studies with 17,500 patients, a hugely significant link between administration of ivermectin and reduced mortality rates in patients with COVID. In fact, the statistical significance of that study was so high that they calculated that the chances of an ineffective drug yielding the same results merely by chance was 1 out of 167 trillion. We also—
Could I ask a question for a moment? Is that interpretation of the meta-analysis based on an expert in clinical trial methodology or statistical methodology?
Is the interpretation of the results that they generated?
That you just presented, yes. Is that from your reading, or do you have an expert to support that interpretation?
Of the Cobos Campos study?
Of the entire description you gave of the meta-analyses, the first one and the Cobos Campos one.
Both those, Justice Cohen, both those reportings of the significance come from both their own abstract concepts and within their own conclusions as to their significance and the calculations of how unlikely or likely it would be that an ineffective drug would yield the same effects.
Okay, but you haven't had a statistical expert or a methodology expert provide their interpretation independently of those reports?
No, a statistical expert was not available to us. But we also would point to a further study by Santine et al., which, after reviewing 7 randomized control studies, noted a phenomenon in Peru in which after a state-sponsored mass ivermectin administration campaign noted a 14-fold decrease in mortality rates in COVID. And when that program was ended under a new president, a 13-fold increase in mortality rates again. Going back to your question, Justice Cullen, those results, to a degree, at least speak for themselves. We have in our factum also pointed to a number of other studies which corroborate these findings.
Could I ask a question? How do you reconcile those studies with the current guidelines that are universally being used where ivermectin is not forming part of the current therapy? How do you reconcile the data you're presenting with current guidelines used globally?
Certainly, Justice Harris. The fact is that guidelines generated by groups such as the NIH, the WHO, or Health Canada are not able to necessarily rely on the most recent and up-to-date medical research. The field of treating COVID-19 is a rapidly changing one, and we here in establishing causation are able to draw from the most recent and up-to-date medical research. Unfortunately, groups like I've mentioned have to go somewhat slower in that process and are not able to necessarily update their guidelines as quickly as might be beneficial. For instance, the guidelines provided by the WHO have not been updated since March of 2021, nearly a year ago to the day, so they are not necessarily going to reflect the most relevant findings. Additionally, those groups have to rely only on studies that apply to the broad public health. In establishing causation for this individual plaintiff, we do not need to rely solely on these meta-analyses. In fact, these meta-analyses only give us an indication of what is likely Ms. Stark would have experienced. But we can also look to her individual response to ivermectin and its administration. The facts are that when she was first administered ivermectin on October 7th, her condition improved dramatically and nearly immediately. When it was removed the next day, she quickly declined and had to be ventilated and placed in a medically induced coma. When then later MAP Plus and ivermectin was again administered, she was able to be brought out of the coma and relied only on a nasal cannula for supplemental oxygen. And finally, when MAP Plus was ended, her condition quickly deteriorated. Her chances of survival plummeted, and some days later, she passed away.
How could you, how is it not possible that there's no cause and effect, that this was within the natural fluctuations of the disease, with the ivermectin being a parallel phenomenon but unrelated contributor?
Certainly, Justice Harris. The fact is that Ms. Stark's change in condition, her fluctuation between improving condition and decreasing condition, were in direct association with the administration of ivermectin. Respectfully, I would remind the court, the only thing we need to establish here is that it was more likely than not. And 4 separate instances of direct and immediate correlation does make causation and immediate causation the most likely explanation. The plaintiff advocates only a common sense approach to interpreting Ms. Stark's change in condition, and a true drug effect seems to be the most likely explanation. While it could have been the natural change in COVID and its progression, that does not necessarily make itself more likely than not, given that it is inconsistent with most patients' response to COVID and its progression. Further, ivermectin itself is a safe drug and could not be thought to have caused those adverse effects by itself. 90,000 doses of ivermectin are given in the United States every week, with no indication of an increase in adverse health effects resulting. All the studies that point to ivermectin as having potential adverse health effects are actually based on when the drug is given at toxic levels, at concentrations intended for animals, livestock, and veterinary care. When ivermectin is administered in safe human doses under a doctor's prescription, it does not yield any of these adverse effects. The defense points to the American College of Medical Toxicology, to say that ivermectin has potential adverse health effects. But that report actually does say that while ivermectin can be toxic at high concentrations, it is generally safe when properly administered. They also point to the WHO guidelines, to which I referenced before, to try and corroborate the fact that ivermectin can have negative health effects. But what those guidelines also say is that the possibility of serious adverse effects is very low due to very serious imprecisions in the only 3 studies they rely upon. They in fact note that when relying only on credible data, there is little to no difference in adverse effects. Also, as I noted before, those guidelines are now nearly a year old.
Yeah,
Further, Dr. Lutsier contradicts himself, and his position on Ms. Stark's progression in her disease is not logically consistent with her symptoms. He says both that when he took over, the damage was already done, and she already had terminal pulmonary fibrosis, yet then claims also that she improved under the hospital's supportive care protocol. These 2 claims cannot both be true. She cannot have both been dying and getting better. We acknowledge and agree with the defendants here that scientific precision is not required in this case. All we say is that on one hand, we have an abundance of data that suggests there is a significant possibility that ivermectin would have saved Ms. Stark's life. And in collaboration with that, we also add that Ms. Stark showed a marked, immediate, and substantial response to ivermectin and its withdrawal on 4 separate occasions, showing that together, on the balance of probabilities, it is more likely than not that had ivermectin continued to be used, Ms. Stark would have survived, thus making Dr. Lutsier liable for her death. My second submission for this court today is that West Valley Memorial Hospital should be held vicariously liable for Dr. Lutsier's negligence. In order to establish vicarious liability at the common law, we look to the Salmon test, which says that to establish vicarious liability, an employee's wrongful conduct must consist of either 1, acts that are authorized by the employer, or 2, unauthorized acts that are so connected with acts that are authorized as to rightly be regarded as modes, albeit improper modes, of doing what has been authorized. The question, looking to the first stage of the test here, which is the most relevant, is to ask, were Dr. Lutsier's actions authorized by the hospital? The facts are that Dr. Lutsier was a paid employee of West Valley Memorial. He was covered for risks by the hospital and performed his actions on behalf of the hospital rather than himself. His authorization and discretion in how he chose to treat patients was granted by the hospital. Therefore, his negligence came from his hospital-granted power. The defendants point to the case of Yeppermian et al. Against Scarborough General Hospital to try and show that hospitals are not held vicariously liable for the negligence of their doctors. But the facts of that case are substantially different to the one that's at hand. In that case, the doctor was not actually a paid employee of the hospital. He worked directly for the plaintiff, the patient. The court in that case ruled that, quote, unquestionably, the hospital would have been liable vicariously for the negligence of Dr. Rosen had he been a paid employee. Dr. Lutsier, in this case, was such a paid employee of West Valley Memorial Hospital. It's fair that if a hospital employs a doctor for their own financial gain, they should also assume a degree of financial risk for any negligence that that doctor might bring about in the commission of their duties to the hospital. There are further policy benefits for finding a vicarious liability in this case. Vicarious liability findings are generally to help provide adequate remedies for the plaintiffs and incentivize employees to help prevent negligence on behalf of their employees. In this case, given the $25.34 million the plaintiff is requesting, the hospital resources would be adequately used to help supplement those amount of damages. And secondly, it would help encourage the hospitals not to allow their physicians to make decisions without taking into account their patients' individual circumstances and making treatment decisions based purely on personal prejudices and biases, and being negligent in how they choose to treat their patients. Therefore, we ask that West Valley Memorial Hospital be found to be vicariously liable for the negligence of Dr. Lutsier as his employer. Based on this and my co-counsel's submissions, we ask that this court find Dr. Lutsier liable for Ms. Stark's death. They find West Valley Memorial Hospital vicariously liable for Dr. Lutsier's negligence, and award to the plaintiff damages in the amount of $25,340,000, the reasoning for which can be found in our factum. Barring any further questions, this concludes the submissions by the plaintiff. Thank you.
The court now invites counsel for the defendants to begin.
Good afternoon, Your Honors. Thank you for being here today. My name is Ethan Zavarella, and I'm joined by my co-counsel, Basil Sabalbal. We will be dividing up our arguments. I will be addressing first the issue of whether our client, Dr. Lutsier, breached the standard of care, and then my colleague, Basil, will be addressing the issues of causation and vicarious liability. I will start my submission by briefly describing the standard of care, what that would be in this case. I believe our learned friends did a very good job of describing that, but I'll go over it again quickly. I'll then address whether the decision not to administer ivermectin or math plus protocol constitutes a breach of that standard of care. We'll take another look at the evidence, and then I will address whether Dr. Lutsier's decision not to further investigate the evidence sent to him by Dr. Strange was sufficient. And then I will briefly touch upon the broader implications that this case has for the medical community. Starting with the standard of care. The standard of care for medical negligence in Canada is an objective one. The standard is set out in Stell versus Abedkov, and it can be described as follows. A physician is bound to exercise that degree of skill and care as expected of a normal, prudent practitioner of the same experience and standing. If Dr. Lutsier's actions were not in accordance with what could be expected of a reasonable and prudent ICU physician in his circumstance, only then could he be found to be negligent. So was there a breach in this instance? Generally, where a doctor has allowed customary procedures of his profession, he will be shown to have met the standard of reasonableness and thus will not be liable. So it is important for us to ask, what are the customary procedures in Dr. Lutsier's position? We believe that a good way to assess customary procedures of a reasonable physician in Dr. Lutsier's position would be to look to COVID-19 treatment guidelines. Why would we do so? We would do so because these guidelines govern the conduct of top physicians, both in Canada and globally. Dr. Lutsier relied on the guidelines of organizations such as Health Canada, the World Health Organization, the Center for Disease Control, as well as others, in the creation of his hospital's treatment protocols, which were updated regularly. These guidelines are in accordance with the leading authorities in medicine. I would just like to bring to the attention of the court that our learned friends reject the usage of the WHO guidelines based on the fact that they claim they were a year out of date. I'm not sure how familiar our friends are with the WHO guidelines because they are updated continuously. And I have pulled up that they would have been updated on, let's see, they would have been updated just prior to this incident on the 24th of September, 2021. So I would just like the court to keep that in mind as I go through. They certainly were not a year out of date, and that's verifiable on their website. So the evidence guiding Dr. Lutsier's decision not to administer Math Plus or ivermectin was the best evidence available to physicians at the time of this treatment. Our client recommended on Health Canada, or he relied on Health Canada for one example. Health Canada only authorizes treatments that withstand a thorough scientific review of safety and efficacy based on quality data. In other words, Health Canada will only approve treatments that work well, are of high quality, and are safe. Remdesivir, the treatment used by Dr. Lutsier, passed this threshold. The preferred treatment, ivermectin, the preferred treatment of Dr. Strange, did not pass this threshold. According to Health Canada, one of our country's leading bodies on medical evidence, there is no evidence that ivermectin works to prevent or treat COVID-19. This is vital to consider because, as discussed, if a physician complied with customary practices established by the profession, they will generally be absolved of liability. I believe that Health Canada guidelines can reasonably indicate what we may expect of a reasonable and prudent physician in such a scenario. But we don't need to just take Health Canada's word for it. We can also look to other leading bodies of medicine internationally, such as the World Health Organization. The World Health Organization's guideline lists numerous key metrics with respect to ivermectin usage and COVID-19 recovery. And with each of these metrics, the results are poor. These metrics include viral clearance, time to clinical improvement, mechanical ventilation rates, mortality rates, hospital admission rates, and more. With respect to each metric, ivermectin has either no effect or an uncertain effect.
I'd like to interrupt and ask counsel a question for a moment.
Sure.
You imply that the test of the standard of care is an objective one. And in saying that, are you implying that it could be determined by looking specifically at treatments administered or not administered or procedures done, for example? Or does it encompass other aspects of the overall care of the patient that can't be assessed by specific treatments administered?
So
such as interaction with patient, family, and other colleagues, and so on.
When I say objective, I'm just referring to the reasonable person standard. So the law sees that as an objective standard, whereas the subjective standard, it analyzes what was actually going on in the state of mind of the person in question. So instead of looking at the person in question, we're kind of extending this to the reasonable physician. So that's what the law sees as an objective standard. So that is what I'm referring to when I say objective.
And so I don't see it addressed in your factum in terms of what that reasonable standard would include beyond particularly the selection of treatment or selection not to use a treatment. I don't see it encompassing aspects of patient counseling or interaction and communication and so on.
Absolutely, Your Honor. I will address communication because I know that is certainly a key issue here. If I may continue, I will get to that point. So I just wanted to establish that the World Health Organization is certainly a credible body of evidence. I don't believe anyone here would dispute that assertion. And I just wanted to address the point brought up by our learned friends that the World Health Organization and these other guidelines are not capable of keeping abreast of the current state of medical research. This is quite frankly not true. The World Health Organization conducts a comprehensive monitoring of all RCTs, all emerging RCTs, and meta-analyses on a continual basis. And as I mentioned, they would have updated this report prior to the incident of Miss Stark. They update this on a continual basis with the assistance of information specialists. They even review data that has not yet been published or released. So how our learned friends could say that the World Health Organization was not staying abreast of the research when they are reviewing research that has yet to be published goes beyond me. So continuing, what stands in opposition to the World Health Organization and the Canada Health Guidelines? I would like to draw the court's attention to the characteristics of the leading proponent of Math Plus treatment and ivermectin, Dr. Pierre Corey. And I would like to question whether Dr. Pierre Corey is a reliable source. Dr. Pierre Corey is guilty of publishing fraudulent information on 2 occasions regarding both Math Plus and ivermectin efficacy. This is your preferred treatment, and these are your experts. If these treatments stood on their own merits, we believe that they would have a favorable mention or even a mention in the case of Math Plus amongst the various respected guidelines that are relied upon by top physicians, both in Canada and internationally. And yet, ivermectin is not treated favorably, and Math Plus receives not a single mention. Our opposing counsel has pointed to some studies that purport to demonstrate that ivermectin has positive outcomes for COVID-19 afflicted patients. However, as we included in our factum from the American College of Medical Toxicology, A number of the studies supporting ivermectin have flawed methodology. They have inconsistent patient selection and even uneven peer review. So it is quite dubious to say or to rely on this research that is favoring ivermectin. I will now address whether Dr. Lutsier breached the standard of care for the amount of investigation that he conducted with respect to Dr. Strange's research that she sent him. Our learned friends state that Dr. Lutsier refused to participate in the exchange of information and that he disregarded novel treatment options presented by Dr. Strange. However, ivermectin is not novel. It has been studied and it continues to be studied in the context of COVID-19, and the research indicates its inefficacy. Dr. Lutsier would have been familiar with this research. Moreover, any exchange of information with Dr. Strange, beyond hearing her fervent endorsement of ivermectin, is not necessary to meet the standard of care in this case. The position that ivermectin should be used as a course of treatment has been studied rigorously by these credible institutions that Dr. Lutsier would have been relying on. A refusal to engage further with Dr. Strange after she made her position clear is what a reasonable and prudent physician would have done. Our learned friends mentioned the testimony of Dr. Moriarty. I would just like to say that Dr. Moriarty is on record as saying that Dr. Lutsier's decision not to delve deeper into the research provided by Dr. Strange would not constitute a violation of the standard of care if he had solid evidence to refute her claims. We posit that the methodologically rigorous nature of these guidelines, such as the World Health Organization and Health Canada, constitute solid evidence. Dr. Lutsier was familiar with these guidelines, kept himself updated on them regularly. These guidelines go out, seek current evidence, they review all emerging RCTs. So we do believe that this constitutes, on the part of Dr. Lutsier, a familiarity with evidence refuting ivermectin. So to suggest that his refusal to delve deep into these studies provided by Dr. Strange is a refusal to collaborate or review the evidence is simply not true. He had reviewed the evidence by virtue of his familiarity with the guidelines that refuted ivermectin's efficacy. That is our position. I would also like to point out to your honors that the College of Physicians and Surgeons of Ontario, who our learned friends cite as an authority, they actually recently took the position that Health Canada has established with respect to ivermectin. There was an Ontario physician who was reprimanded by the College of Physicians and Surgeons of Ontario primarily for his insistence on prescribing ivermectin to COVID-19 afflicted patients. We posit that any reasonable and prudent physician would meet Dr. Strange's assertion with great skepticism, especially in light of the fact that the College of Physicians and Surgeons of Ontario, a body that our learned friends cite as authoritative, has penalized physicians for using this very course of treatment. So I believe that Dr. Lutsier, our client, can be forgiven for not delving further into that research in light of his familiarity with the guidelines and his presumed knowledge of the College of Physicians and Surgeons of Ontario's stance on ivermectin use. To finish off,
Council, I just have a quick question.
Mhm.
Even if we accept your argument that Dr. Lutsier followed an acceptable course of treatment, does he not have a duty to reassess when his course of treatment is not providing a beneficial effect?
Dr. Lutsier actually, he contests that in the materials, and he is on record as saying that if he would have been able to continue with his course of treatment untampered from the beginning, it is almost a certainty that the patient would have been fine. And he had used his guidelines on similar patients. He had a track record of success using this exact supportive care that he had been using. So yeah, that would be my response.
I'd also like to ask a question, Council. Do we not
Sure.
also need to assess the sufficiency of the treatment that was provided by Dr. Papadopoulos and Dr. Park, who both administered ivermectin with positive results?
Sure, I would just like to say that correlation does not equal causation. And we have no possible way of knowing in that instance that the correlation in the reduction of symptoms was brought on by ivermectin in that case, or whether it was any other number of factors that was leading to a recovery. So that would be my response.
But do you also contend that the treatment by Dr. Lutsier, which counteracted the treatment by Dr. Papadopoulos and Dr. Park, left the patient with an insufficiency of treatment after beginning a course of treatment and ceasing it twice?
That his was insufficient after the interference?
Yes, that the 2 interferences in his treatment left the patient with an insufficient course of treatment.
The options available to the doctor at that point were to recommend to go ahead and use a drug that that other physicians have been penalized for using by his organizing body. So that's really a difficult situation to be in. And I would not fault our client for refusing to use that treatment, given that to his knowledge and to the best evidence available to him, that treatment was ineffective. Thank you for your question, Your Honor. I just have one more point to finish off with here, and this is with respect to the broader implications for the medical community. I just wanted to mention that if our client is found to be liable for relying on what is the best evidence available to him, and for acting in accordance with his professional body, I'm wondering what this says for other physicians in the field. We believe that this tells other physicians that they can be diligent, they can be thorough, they can rely on leading societies of medicine, and that the law may still not protect them. There is a delicate relationship here between patient and physician, and this delicate balance can be disrupted by a hostile patient quite easily. This may sow distrust in the public and greatly weaken a doctor's ability to carry out the vital role that they have in our society. In light of this, I would like to bring to the court's attention that successful medical negligence claims are incredibly, incredibly rare. 1.6% of medical negligence cases in Canada result in the physician being found liable. And there is good reason for this, given this delicate balance between patient and physician in our society. So, Your Honors, for the sake of upholding the integrity of our healthcare system, we ask that you dismiss this action and find our client not liable. Thank you. I will now pass it along unless there's a question.
I have one quick question. Would you concur that a poorly or non-communicative physician is places equally at risk the patient-doctor relationship as a hostile patient, as you presented it?
Are you referring to our client as potentially being demonstrating poor communication?
I'm referring to the circumstance you envision where a hostile patient creates a challenging environment for a physician, and I'm asking if you concur that poor communication on the part of the physician or poor sensitivity to the patient's concerns can equally create a hostile environment for the patient and medical legally for that very same physician themselves.
I do not. That may create a hostile. It certainly did create a hostile environment with the patient. But as I mentioned, given the rarity with which physicians are found liable for a breach of standard of care, I do not believe that ruffling the feathers of Mr. Stark would have amounted to a breach of the standard of care, especially in light of our doctors' reliance on the leading societies of medicine's recommendation in treatment. So while perhaps I will say our client could have acted more collegially, but I do not think that the law can find him liable for his failure to act a bit more collegially with the patient's family.
Okay, thank you.
I will now pass it over to my co-counsel, Basil Sabalbal, who will be discussing the issues of causation and vicarious liability. Thank you.
Good afternoon, Your Honors. As my co-counsel mentioned, I'm Basil Sabalbal. Before we start, I would like to give a quick roadmap on exactly how my argument is going to proceed today. I'll begin by speaking on the FLCC, the Frontline COVID Critical Care, that our friends seem to have depended a lot on for their research, and why their recommendations, not our friends, but the FLCC, recommendations and studies should not be relied upon, along with many other studies advanced by opposing counsel and found elsewhere. I'll also then discuss the issue of causation and how Dr. Lucier's conduct did not cause the unfortunate death of Ms. Stark. I will then conclude with discussing the issue on vicarious liability and how West Valley Memorial Hospital is not liable for Dr. Lucier's actions in this case. The FLCC is formed by a group, FLCCC, correction, is formed by a group of physicians and media professionals who advance the use of ivermectin as a cure-all for COVID-19, and is led by two doctors, one of which is Dr. Corey, as my co-counsel mentioned, was found guilty of publishing fraudulent research regarding the efficacy of ivermectin and MAP+. Dr. Corey told members, prior to him being found guilty, he told members of the Senate Homeland Security Committee in December 2020 that ivermectin is quote, a miracle drug against COVID and had profound efficacy in all stages of the disease. He further claimed that if everyone had access to ivermectin, the pandemic will come to an end and the economy will reopen. This, as we clearly see today, is not the case. Ivermectin treatment, this case, a lot of it has to do with the which study is better, I guess, and if ivermectin is indeed an effective method for treating COVID-19. What everything has been pointing to is ivermectin treatment is flawed or inconclusive and is not recommended by Health Canada. A large number of studies, credible studies, had inconsistent patient selection and uneven peer review, as my co-counsel mentioned. Shortly after the passing of Ms. Stark, the American College of Medical Toxicology released a position statement declaring that there's no evidence ivermectin improves outcome for COVID-19 patient, and that the drug may even worsen outcomes. A recent randomized clinical trial with high-risk patients with mild to moderate COVID-19, ivermectin treatment during early illness did not prevent progression to severe disease, and the study does not support, again, the use of ivermectin for COVID-19 patients. I just want to note that this particular article was published on February 18th of this year by JAMA Internal Medicine, which is a monthly publication, a peer-reviewed journal by the American Medical Association. This particular journal impact factor ranks it 7th out of 169 medical journals. There are currently no Canadian cases that deal directly with ivermectin in the context of COVID-19. However, a decision by the Ohio court in the fall of 2021, in answering the issue if an injunction should be granted forcing a hospital to administer ivermectin to a COVID-19 patient when the hospital's doctors, FDA, CDC, and the AMA do not believe the ivermectin should be a recommended way of treatment for COVID-19. In his decision, the judge did not grant the injunction and stated, and I quote, "There can be no doubt that the medical and scientific communities do not support the use of ivermectin as a treatment for COVID-19. He continued to comment that even though there were some doctors and studies that supported the use of ivermectin, the studies that support such use have had, and I quote again, inconsistent results, limitations to the studies, where open label studies were of low quality or low certainty, included small sample sizes, various dosing regimes, or have been riddled with issues that the studies themselves were withdrawn." Now, as far as causation, Dr. Lucier testified, during his discovery, that had he started treating Ms. Stark earlier in her treatment, he could have saved her. He asserted that he began treating her once the damage had already been done. Ms. Stark tested positive for COVID-19 on October 1st, without going too much details into the statement of facts, but she was admitted into West Valley Memorial Hospital October 5th. She continued to get worse and then moved to the ICU on October 8th. And the treatment began her COVID-19 protocol, which Dr. Lucier, along with the hospital expert panel, developed. However, on October 7th, at the pleading of Ms. Stark's family, she was given ivermectin by another doctor, which he's just a third-year resident, not to discount it, but he's a third-year resident. He's not at the expertise level of Dr. Lucier. It should be noted that the hospital's protocol is based on a package of literature updated monthly with sound and peer-reviewed research supported by the CDC, FDA, the WHO, and Health Canada, as my co-counsel mentioned. Further, these guidelines are championed by leading societies in medicine. The hospital's expert panel last updated that particular package on September 20th, just days before Ms. Stark arrived to the hospital. And that update would have included the most recent and most credible medical research that would support or treat COVID-19. Dr. Lucier, in his experience working with COVID-19 patients since the onset of the pandemic, developed expertise in treating patients and can confidently and credibly speak on the actual cause of Ms. Stark's deteriorating condition. He asserted that Ms. Stark was getting better while on the hospital's COVID-19 protocol, but would then get worse because of the tampering in the treatment itself. This assertion is supported by the risk of serious adverse effects associated with the use of ivermectin, as mentioned earlier. The studies have shown that there are serious adverse effects. And again, these studies are based on credible research. There's yet to be a cure for COVID-19. The mere fact that Ms. Stark was displaying signs of improvement does not signify the drug was the cause. Our friends mentioned that it was at 4 separate correlations that this was occurring. Actually, it was just the two times that she was doing it. And that's after a significant time has gone by on the hospital protocol. And just within hours, this supposed miraculous drug began to see treatment, which is, clearly somebody that's going through such a serious medical condition doesn't improve within an hour or two.
Counsel, are there any circumstances where it would be justified to use a treatment that has a lower standard of clinical evidence to support its use?
Your Honor, I agree with you. I think there would be, especially in cases, and actually as Dr. Lucier spoke to it in his discovery, that at the time when COVID-19 was starting to, on the onset of COVID-19, it was an unknown. Nobody knew how exactly we can do this. So I would actually be on my friend's side in if that particular treatment was given to them on the onset of COVID-19, where again, nobody knew what exactly can be treated and how it could be done. But since then, and since ivermectin has actually been out since over a year by the time Ms. Stark was admitted to hospital, research has continually proven and discredited any research that actually supported the use of ivermectin. So yes, if there was some drug that happened to have come upon, Your Honor, and was found to, there was some credible or some research that suggests that there is going to be improvement, I say yes, go for it. But at this is definitely not the case in our situation right now. Thank you for your question, Your Honor. So again, as I was saying, there's yet to be a cure for COVID-19. The mere fact that Ms. Stark was displaying signs of improvement does not signify the drug was a cause. As my co-counsel spoke to it earlier, it's wisely held in the scientific community that correlation does not equal causation. It is more probable that Ms. Stark's improvement was a result of the proven hospital's COVID-19 protocol, which again is backed by credible scientific and medical authorities starting to take effect. COVID-19 protocol would have likely saved Ms. Stark if the treatment was not tampered with, again, and that's based on Dr. Lucier's years of experience with the pandemic, the 2 years that he's been in the ICU. In considering causation, Justice Sapinka and Snell highlighted that some courts have assumed an unrealistic posture in respect to medical experts to give conclusive evidence that an act caused a given result, and that medical testimony does not lend itself to precise conclusion because medicine is not an exact science. In the present case, it cannot be said conclusively what caused Ms. Stark's death, along with what effects ivermectin or mouthwash had on her. By the time Dr. Lucier started treating Ms. Stark, she had already entered the pulmonary phase, not a terminal phase, pulmonary phase, just to correct my friends. The hospital's COVID-19 protocol, when not tampered with, had been effective on patients fitting Ms. Stark's profile. However, given the tampering in the treatment with a drug associated with adverse risks, and the fact that credible medical bodies condemn the use of this drug for COVID-19 patients, the tampering may have caused Ms. Stark's unfortunate death. As for the claim of negligence for not reading Dr. Strange's literature, Dr. Lucier is privy to a wide array of literature concerning the treatment of COVID. He trusts his team who established a scientific backed treatments for which he'd been heading in support of medical and authoritative organizations such as Health Canada, WHO, CDC, and FDA. Dr. Lucier, in fact, did open the literature and immediately dismissed it. And I can only gather to guess, but the literature itself just highlighted FLCCC on the very top and immediately dismissed this as probably not credible. He still relied on his training, expertise, and experience for the last 2 years. And not to mention that just days prior, they just updated the COVID-19 protocol based on the most recent studies. This literature that's in dispute and that what we're talking about was sent in by Dr. Strange, who had since been asked to step down from her role in the critical care unit at her hospital because of administering ivermectin. Furthermore, she was issued a warning by the College of Physicians of Ontario for the very same reason. Dr. Lucier was not negligent at all in not listening to Dr. Strange on his refusal to rely on her research. Furthermore, there's no evidence that the transfer would have let Ms. Stark live and when she was under Dr. Lucier's care. And he felt that he had the duty to treat her. Mr. Stark was advised by our client that Ms. Stark had 20% chance of survival rate on October 15th. Dr. Lucier, in protecting his patient, likely felt that the transfer would most certainly kill her in that she would have removed from the crucial COVID-19 supportive care. Now, moving on to West Valley Memorial Hospital and vicarious liability. It's Yepriman is a seminal case which establishes vicarious liability. In respect to hospitals and their staff, and the fact patterns in Yepriman actually, in fact, are the same as the matter in hand. In Yepriman, the hospital appealed the decision on the trial judge in finding liability against it for the actions of a physician. The trial judge was found the doctor negligent for not administering treatment for diabetes soon enough and in sufficient quantity. As a result of this negligence, the patient went into cardiac arrest, which caused permanent brain damage. On appeal, the court raised the question of whether the hospital undertakes to provide medical care or to select competent doctors who will provide it. The court stated that the public can expect a large public hospital to provide treatments for seriously ill and injured people, but to add no further expectation on the hospital to pay for a negligent mistake by a doctor on the medical staff. The court added that the public expects the hospital had picked the staff with great care and checked out their credentials. The court implied that the hospital undertakes to select competent doctors that will provide medical care. The hospital, in essence, holds an administrative responsibility to ensure medical services are available. The doctors act independently from the hospital, and that independence is controlled by their peers. In reaching their decision, the court noted that although the doctor was found to be negligent, there were no suggestions that he was incompetent, and there was no evidence of the lack of care by the hospital board in appointing the doctor. The court allowed the hospital's appeal and dismissed the action against it. This very much resembles the present case in that there are no suggestions that our client was incompetent, and there's no evidence to indicate that the hospital was negligent in appointing him. In a recent
brief interjection, if it's okay.
Yes.
I'd like to touch on your argument that Yepriman should be followed in this matter. However, I see from the plaintiff's factum that they reference the cross-examination of Dr. Lucier in that Dr. Lucier was an employee of the hospital and not an independent contractor, as was the case in Yepriman. Would you speak to that?
Absolutely, Your Honor. So in that case, in Yepriman, you're absolutely correct. They were not an actually contracted employee by the hospital. In our present case, Dr. Lucier oversees the medical emergency department. So he oversees the operations on day-to-day operations, again, probably reviewing the treatments that are being given. I would hazard to guess it's like a semi-administrative / operational duties, and that's what he's hired for. Again, the patient does not pay the hospital directly. Everything is billed to OHIP. So in the end, any treatment that's received, the hospital does not direct that treatment. And it's as we've seen in Canada, because we do have public hospitals, it's directed by their peers and the College of Physicians. I would guess if this was a little bit of a different case where in essence it was a private hospital where the hospital has immediate hands in exactly how to direct it without any public input, then I would say yes. Then in this case, it wouldn't apply, but not in our case. If again, Dr. Lucier was acting as giving medical treatment, not necessarily ensuring the proper running of a hospital, which I will definitely continue. I'll be covering very quickly here,
Yeah.
if you allow me, Your Honor. So as I said, just to make sure that reappraisement is still valid, because it is a bit of an older case. In a recent decision in Hearst, the court did reference this case, noting that it is settled law that the hospital is not vicariously liable for the actions of the defendant doctors. The case concerned the actions of the defendant doctor who performed a procedure, and is very similar to this case before this court, in that our client was acting in his capacity as a medical practitioner, independent from the administrative duties of the hospital. In the present case, like again, as I said, the main concern is the receipt or lack thereof of a particular treatment. The distinguishing factor is that in Yepriman, the doctor was found to be negligent in his action, and still yet in Yepriman, the hospital was not vicariously liable. Opposing counsel brought to our attention Como v. St. John Regional Hospital. Would like to point out that the court found the hospital vicariously liable, not because of the negligent acts of the two doctors involved, but because the hospital's breach of duty in failing to enforce its policies. The failure to abide by such policies resulted in the plaintiff's or his family's in the plaintiff's death. Furthermore, the judge highlighted that the most common duties owed by a hospital to patients are to select competent staff and to monitor their continued competence, to provide proper instruction and supervision, to provide proper facilities and equipment, and to establish the systems necessary to the safe operation of the hospital. So again, nothing really necessarily specifically speaks to the actual medical treatment that's given to the patients. We do not reject the argument that the hospital granted Dr. Lutze discretionary power. As I said, this power is regulated by the College of Physicians and Surgeons of Ontario. Dr. Lutze does not answer to the hospital in regard to treating his patients, but to the college itself. The hospital's position is to simply do their due diligence in their hiring practice of a competent physician to fill the roles required by the hospital. Opposing counsel had not provided any evidence to suggest that the hospital was negligent in their hiring of Dr. Lutze or that is competent. I believe I've elapsed my time here, Your Honors. I'm just going to quickly wrap up. In conclusion, the FLCCC and any linked studies have been proven to lack credibility and in no way is supported by authoritative and credible medical organizations. Dr. Lutze is not reading the literature, reading the literature that further advances the FLCCC agenda, forwarded to him by Dr. Strange, who since been issued a warning by the College of Physicians and Surgeons of Ontario, along with being removed from her position at the hospital was not a causal link to Ms. Stark's death. In fact, we've yet to see any evidence that tells us exactly what the cause of death was. As for vicarious liability, it is settled law that the hospitals are not vicariously liable for medical treatment administered by their doctors. There's no evidence to show that West Valley Memorial Hospital was negligent in hiring Dr. Lutze, and no evidence to show that Dr. Lutze is an incompetent specialist. Quite the contrary, Dr. Lutze is an accomplished specialist who is well respected by his peers. Your Honors, we ask that you dismiss this case and not find West Valley Memorial Hospital or Dr. Lutze liable for any of their actions and with cost. Thank you so much.
The court now invites counsel for the plaintiff to begin their optional 3-minute rebuttal.
Yes, thank you. I anticipate it'll be shorter than the full 3 minutes. Just a few points, Your Honors. First, just to be clear, the plaintiff does not reject the use of WHO guidelines, which was noted by our friends. My co-counsel was responding to Justice Harris's question when bringing up the specifically the date of update of the WHO guidelines. The date on the page specifically pertaining to ivermectin was last updated on February 11th, 2021. This was several months, almost a year before the incident occurred in October. And many of the studies that my co-counsel used with regards to the causation argument occurred in August. So he was merely bringing up these date discrepancies to suggest that that's possibly why the guidelines are the way they are. It's not to say that they would necessarily be changed, but it's just pointing to the evolving nature and the date discrepancies there. Second, with regards to the case brought up by our friends with the doctor being disciplined, if you look to the article, it does not say that the doctor was disciplined for prescribing ivermectin.
The doctor engaged in a slew of very unprofessional conduct on social media, and that was primarily why he was being penalized. However, the outcome of that was that he was barred from engaging in certain activities. One of these was prescribing ivermectin. So it's not that the CPSO has penalized someone or disciplined someone or sanctioned someone for prescribing ivermectin. There was a slew of conduct related to spreading COVID misinformation, essentially criticizing government mandates and things like that. And lastly, just briefly, to clarify, when my co-counsel stated that there were 4 separate occasions that we could look at to see the true drug effect, he was referring to addition, removal, addition, and removal. So yes, ivermectin was administered once and Math Plus was administered once, but when he was referring to the causation piece, he was suggesting that, again, we have an addition and a removal twice, leading to essentially 4 separate reactions, and that's what he was referring to. That finishes the rebuttal on behalf of the plaintiff. Thank you. And this concludes the matter of Stark and Lutsier.